Call on Members' Order of the Day number 4.
Mr Speaker.
Telecommunications, Interception, Capability and Security Amendment Bill, first reading.
Mr. Speaker.
Claire Curran.
Thank you, Mr Speaker. I move that the Telecommunications, Interception, Capability and Security Amendment Bill be now read a first time, and I nominate the Government Administration Committee to consider the bill. Mr Speaker, 2013 was a tumultuous year for New Zealanders as we faced the realisation that the interception and electronic surveillance capacities of our secret service agencies had expanded enormously. It was the year that Edward Snowden revealed to the world just what the US was capable of and was actually doing. And it was the year that the Five Eyes relationship came under intense scrutiny. It was the year that this government introduced 2 pieces of law to give the GCSB and ministers expanded powers, and it was the year that civil society, including the Human Rights Commission, spoke up loudly about the importance of privacy and balance in our security laws. Labor strongly opposed both those laws. We did so for many reasons. During the debate around the introduction of the GCSB and the Telecommunications, Interception, Capability and Security bills, or the otherwise known as TICs, in 2013, there were numerous submissions from civil society, the legal profession and the telecommunications and internet sectors for there to be greater independent oversight of the new powers being provided for in both pieces of law. And during the debate on the TICs bill, a number of submitters urged the government to include a technical advisory board to act as an accountability buffer for the GCSB and the government minister exercising powers over the commercial decisions by our telecommunications networks with no independent oversight. In clause 48 of the bill, which is now an act, these powers include any decisions by a network to buy or acquire any equipment, system or services that falls within an area of specified security interest, or any changes to the architecture or design, or ownership, control or oversight or supervision of any equipment, system or service that falls within an area of security interest. Mr Speaker, these are enormous powers. If the GCSB decides to intervene and the network challenges that decision, the issue goes to the minister responsible for the GCSB. There is no other check or balance in the system. After the bill passed, without the inclusion of any independent oversight mechanism, I placed a bill into the private member's ballot to rectify this, and after more than 2 years, my bill has been drawn. This proposed amendment to the Telecommunications, Interception, Capability and Security Act establishes a technical advisory board to which matters must be referred in instances where the minister will be required to exercise his or her discretion or prescribe an additional area of specified security interest. Mr Speaker, one of the serious concerns around TICs is that it will create a chilling effect on New Zealand technology companies as the powers for surveillance agencies to interfere in business decisions are too broad and the compliance regime is too rigid and secretive. It created broad sweeping powers likely to result in an increased risk of invasive surveillance on a mass scale, and that it failed to provide sufficient oversight or checks and balances on the new powers granted to ministers. We considered that the bill was poorly drafted, with the Select Committee finding the powers were not clear or too broad. My bill can't and won't address all of those issues, but what it does do is establish a mechanism for there to be expertise to assist the minister and assure New Zealanders that relevant information is being considered where critical decisions are being made about network security and consideration of proposed mitigations. The bill will require any matter where a minister exercises their discretion or recommends prescribing an additional area of specified security interest, be first referred to the Technical Advisory Board for analysis and recommendations. That board will comprise equal representation from government and the industry with an independent chair. So why is it needed? Because there are things that the network or telecommunications companies get asked to do by the GCSB that are either technically unfeasible and expensive. The GCSB does not have the capacity to understand the rapidly changing technology, the impact on wider industry, and if they are delaying decisions being made by our industry to become more agile and responsive to the needs of customers and businesses, then this has an economic impact. I want to refer specifically to the submission to the 2013 bill made by the Telecommunications Carriers Forum, or otherwise known as the TCF, which is a respected body which represents most of the telecommunications networks in New Zealand. They said that they recommended that additional protections are put in place relating to the issuing of directives. We consider that an additional step in the process between the security agency and the minister should be inserted into the consideration process to appropriately address concerns, and they considered that the UK approach on which their submission is based achieves this well. And they went on to say that an independent expert panel should consider any directive proposal from a security agency and submissions from impacted parties before providing its recommendation to the minister. And that panel would be balanced by an equal number of security-cleared security specialists from telecommunications providers and representatives from security agencies with an independent chair. All participants would have secret-level, government-sponsored security clearance. Mr. Speaker, this is eminently sensible. It's measured. It was supported in the Select Committee by all of the other major telecommunications companies in New Zealand, including Chorus and Able, who are rolling out our UFB networks, Telecom, as it was then, which has now been divided into Chorus and Spark, Ultrafast Fibre, another infrastructure company rolling out fibre, Vodafone, and also Google. Mr. Speaker, in summary, what this bill does is set up a board, a technical advisory board. It will improve relationships between the security agencies and the telecommunications companies. It will ensure that businesses are not burdened with unnecessary costs. It will reduce the likelihood of mistakes from all of those involved parties, such as the GCSB, the Minister, and the telecommunications companies. It's not going to impede security. All of the panel must have top-level security clearance, and they're advisory only. They do not have ultimate decision-making power. The Minister would still make the final decision if necessary. There is no harm in ensuring that the Minister making these decisions is as fully informed as possible before they make a decision. And this has an overseas precedent. It's based on an existing UK model which has had no issues. The underlying principle is that New Zealanders must be reassured that measures to ensure the security of our public and our private sector entities are balanced by measures to protect their privacy. The creation of this independent board with technical knowledge and expertise is widely supported by the industry, internet and civil society organisations. Since 2013, I have been advised that this existing Act has caused significant costs and delays for companies making business changes and entering into new contractual arrangements. So surely, if there is a low-cost, simple and effective measure that can be put in place to mitigate it, why not do it? It's a sensible bill. It's aimed at making our surveillance laws more efficient and effective. It's got a wider set of principles around mitigating against the economic impact of tightening our security laws while ensuring the best possible advice is being given to the decision makers, whether they're the GCSB or a minister. I ask the House to support this bill to Select Committee.